Hi, everybody. Good evening. Thank you for joining us. I'm Dominic Robato. I'm a staff attorney with Legal Aid of Northwest Texas. We're going to be talking today about some housing issues, but before we get to that, I wanted to talk a little bit about what Legal Aid of Northwest Texas is and what we do as an organization. So Legal Aid of Northwest Texas is a nonprofit organization. We serve a large 114 county area in North and West Texas. And you can kind of see that area in this image right here. We serve all of DFW, all the way over to Odessa, up in North Texas. So we serve a significant area of Texas. Our office, we're from the Denton office, and we serve Cook County, Denton County, Jack County, Montague County, and Wise County. We provide free civil legal services to eligible low-income clients in North and West Texas. So anybody who lives in our service area that has any sort of civil legal need, we can accept an application from them and see whether we're able to provide them some free assistance from an attorney. We help in a lot of different areas, such as wills and estates, federal tax issues, benefits cases, foreclosure cases, consumer cases, community revitalization cases. We also do things like family law is one of our big areas. So we help with a large number of different civil legal problems. What we don't help with is certain types of cases. We don't do medical malpractice cases, class action lawsuits, anything related to assisted suicide or abortion-related litigation. We don't do personal injury cases. We also can't provide assistance on criminal cases. In order for us to be able to provide you some assistance, first of all, we need you to submit an application. We'll look at that application and see whether you're income eligible, whether you're asset eligible, whether you're a U.S. citizen or if you qualify under another legal status, and whether you have a legal problem that fits it within our approved priority list. So in order to be income eligible for our program, you have to be at or below 200% of the federal poverty line. So for an example of this, a family of four would have an income of $52,400 or less. And we have a copy of that eligibility chart on our website at internet.lanwt.org. In order to be asset eligible, you have to have total assets. And when I say assets, we're talking about things that you could currently sell or cash in your bank account. That's going to be less than $10,000 plus $5,000 for each additional family member. So if you had a family of four, you could have up to $25,000 in assets and still be eligible for our program. Additionally, you either have to be a U.S. citizen or you have to have another permanent legal status in the country. This can be a permanent resident, a permanent refugee, or a permanent asylee status. If you are not a U.S. citizen and you don't have that legal status, we might be able to assist you if you're a victim of domestic violence and if the case is related to that domestic violence, such as a protective order or divorcing an individual who has abused you. And then just as an example of some of the priority cases, the types of cases that we accept, consumer and finance cases like predatory lending, deceptive trade practices cases, education cases, family law cases, housing, health cases like Medicaid and Medicare cases, and income maintenance. So this would be anything that helps you maintain an income if you're a low-income household, such as getting unemployment benefits, helping you get a driver's license, stuff like that. If you are interested in applying for services with Legal Aid, we'll first pre-screen you and see whether you're eligible. Then we'll go through all sorts of questions with you and get your information about what exactly it is that's going on that we could help you with. We'll staff that within our organization, see whether or not we want to accept your case. And then If we review that case and we decide we want to represent you in that matter, then we'll send you some documentation so that we can help you out. Otherwise, we always try and at least provide advice to people who are eligible for our services who apply. Some things to keep in mind about our organization during the coronavirus. They are temporarily closed. This actually just got extended today. We're actually closed through the end of July now, and it might go on past that. But we are still providing services remotely. All of the employees are working from home, just like I am. So you can still apply for services. If you're interested in applying, there's a bunch of different ways. You can apply online at landwt.org. You can also call your local office. Our phone number is 940-383-1406 here at the Denton office, which serves Wise County. Like I said, you can apply on our website. You can also call Legal Aid Line. This is an intake line that we have set up where it's staffed by attorneys, and you can call them and speak with an attorney about your legal problem that same time. If you're interested in calling Legal Aid Line, you can call them at 888-529-5277. And finally, I just wanted to talk with you guys about some resources that we have. We have our website here. If you go to internet.landwt.org/COVID-19, you can also find some resources that we've put together related to the coronavirus. We've put together some videos related to the coronavirus on our YouTube channel. There's all sorts of great resources on our website and on our YouTube channel and social media. So if you're interested in any of that, come and check it out. And that's just about it. That's what I wanted to tell you guys about legal aid. Again, if you want to apply, you can call our local office at 940-383-1406. We also have some upcoming clinics where we're going to be doing some intakes with people. So if you want to apply, feel free to give us a call. But otherwise, I'm going to turn this over to Jennifer Connell, who's going to be talking to you guys about some housing issues during the coronavirus pandemic.
Hi there, my name is Jennifer Connell. I'm going to talk to you a little bit about evictions and housing issues during the coronavirus pandemic. I do want to tell you that there is a lot of information involved with this, and every case is very fact specific. So I'm going to give you general information, but I do encourage you to apply to get more fact specific information for your case should you have one. So here's a brief overview of a general eviction suit. Okay, so a suit is generally filed when a tenant has violated the lease or is a holdover. The violation can be criminal activity, non-payment of rent. There's a whole list of them. And so if a tenant violates the lease, they have to be given, per the property code, a notice to vacate from their landlord. Generally, that's 3 days, but landlord-tenant law is very contract specific. So your lease may say 1 day, or it may provide up to 30 days. The landlord has to give you that notice to vacate properly. It should be posted on the inside of your door, absent having, like a large dangerous animal or something like that. It can be given to you via mail or certified mail, or hand-delivered to someone over the age of 16 at your home. Once the notice to vacate period has expired, if you have not left, they can file a petition for eviction in the local JP court. At that time, they would be given, a trial date, and a citation would issue, which would be delivered to you by the constable. So you would have notice that there's going to be a hearing. It's very important that once the hearing is set, which is generally within 10 to 21 days, that you show up to that hearing. If you do not, they will get a default judgment against you. If your landlord manages to obtain an eviction judgment for possession against you or for non-payment of rent, you have 5 days from the date of that hearing to appeal that judgment. You can appeal that with what's called a statement of inability to pay, which the clerk will provide for you. And that lets the clerk know and the court that you can't file the appeal fees, or you can't afford, the appeal fees. If you do not apply or appeal within those 5 days, the landlord obtains what's called a writ of possession, and the constable can then come out and forcibly remove you from the home. So that's the general kind of brief overview of an eviction suit. Right now, during the coronavirus pandemic, the government has enacted the CARES Act. It's a federal eviction moratorium, which protects certain types of tenants from eviction for non-payment of rent from March 27th, 2020 through July 25th of this year. So during this time, the landlords cannot charge late fees, they cannot provide you with a notice to vacate, and they cannot even file an eviction until after July 25th, 2020. After the July 25th date, they can begin to charge late fees, they can provide you with the notice to vacate, but they have to give you at least 30 days notice, no matter what your lease says, and they can file the evictions. The tenants that are protected under the CARES Act are tenants who rent from a landlord who has the federally backed mortgage loan through HUD, the VA, USDA, Fannie Mae, or Freddie Mac. Plus, any tenants who are on public housing, who live in low-income housing tax credit properties, are on Section 8 vouchers or housing choice vouchers, or if they're on the rural voucher program. So all of those tenants are protected. In terms of multifamily properties, if the borrower is in forbearance right now on their mortgage because of the coronavirus pandemic, and it's a federally backed loan, they cannot evict for non-payment of rent. During the period of forbearance, they can't evict or initiate an eviction solely for non-payment of rent, charge any late fees, penalties, or other charges for late payment of rent, or issue the notice to vacate. Following the expiration of the forbearance, a borrower may not require a tenant to vacate the tenant's unit before a date that is 30 days after the date on which the borrower provides the tenant with a notice to vacate. The CARES Act does not apply to the following, and is very important because this has been a source of confusion. It does not apply to eviction cases that were filed before March 27th of this year, cases with purely private landlords with no federal funding, so none of the exemptions we talked about before, eviction cases in which the grounds for eviction are alleged non-rent lease violations. This could be breaking community rules, criminal activity, anything like that. It's solely for non-payment of rent. During the moratorium, rent must still be paid. If you pay your rent, I encourage you to earmark or make copies of the money that you provide to the landlord. If you pay in cash, get a receipt. If the landlord has the right to evict if rent is late, the landlord has the right to evict if the rent is late, even if the tenant later pays in full. Generally, the rule is you have to pay by the 1st, no matter what your lease says is the grace period, and you must pay in full, not even a dollar short. If a tenant cannot pay their rent, we encourage them to communicate with their landlord. You can call 211 to apply for assistance. Anything that you agree with your landlord on, you need to get in writing so that you have it for proof later. You can get it in a written text or an email, but nothing, try to get something in writing that confirms any oral agreements with the landlord. The tenant must pay late fees unless the landlord waives them, which you should also get in writing, or the CARES Act applies. There's a lot of self-help acts that we're seeing. I'm going to tell you about the most popular ones and kind of what the rules are surrounding them. We're seeing a lot of landlords try to lock out their tenants. In order to do a lockout, the tenant must be delinquent with rent. The landlord has to give you proper notice. They can't remove your door or anything like that. And if you provide a request for your key back within 2 hours, or they must provide it back to you within 2 hours. The remedy for this situation is called a writ of reentry and a suit for improper lockout. The same thing with utilities. They can't just cut off your utilities for any other reason than if there's an emergency, and it has to be bona fide, the water line breaks, there's a gas issue, and this is true even if the tenant has not paid rent, unless, of course, the lease permits it, which, again, this whole area of law is very contract specific. The remedy for a utility shutoff is called a writ of restoration. All of these remedies would be filed with the local JP. If your landlord is refusing to make repairs, you have to ask them, you must ask them in writing. You can do it once via certified mail or twice via regular mail. And they have what's called a reasonable amount of time to address that issue. If it's something that, affects your health or safety, that amount of time is much shorter. If it's not really affecting your health or safety, it can be from 3 to 7 business days, but they should fix it. And there are many, many remedies. If they do not, you would bring suit. And, again, that's very fact specific. So if you are having that issue, I encourage you to apply and talk to an attorney about that. There are also provisions in the property code for victims of family violence. This is a defense to the eviction for criminal activity. I talked about that earlier, which, comes up a lot of times for anything that's not a non-payment of rent. They can't evict or penalize a tenant for the presence of police or emergency assistance due to family violence. And with proper documentation, something from a doctor or the police report or any of the abuse advocates, you can actually break your lease, but you must vacate. And you can do so without penalty. Right now, most hearings are being held via Zoom. There's not a lot of in-person hearings. One thing that we're seeing is that access to technology is an issue. So if there's a virtual hearing scheduled, like I said, you still have to show up or you will get a default judgment against you. So you need to make sure that you have a reliable computer and reliable internet connection. You can also access Zoom and a lot of the apps on a mobile phone. The plan B, if you don't have access to those, is to try to find someone who does, maybe a friend, a family, case manager, someone who can help you make sure to show up at that hearing. It's also important that when you attend a virtual hearing, that you make sure you're in a quiet, private location. You don't want children running around or dogs barking, things like that, because you want to be able to present any defense that you have. So you want to make sure that there's nobody else in the room. Like Dominic said, we're here to help you with these issues. We are especially prioritizing evictions right now because there's a pandemic. We don't want people to be kicked out of their home. So please apply either online, by calling the legal aid line, or by calling our local office. I will tell you that, a lot of times the local numbers are quite busy. If you call the legal aid line, you will talk to an attorney who will give you advice and who will direct your application to the correct local office. I want to thank you guys so much for having me.